Good morning to you, those of you on the West and Prairie folk, and good afternoon to those of you in the East. My name is Penny Stewart. For those who weren't here yesterday, I'm the president of the Harry Crowe Foundation, and a very, very warm welcome to the second day of our conference today. I wanted to just take 2 minutes to just recap a few of the ideas that we heard during yesterday's talks, and we can take them up further later in the conference if you choose. So I wanted to start out by saying one of the things it seemed to me important that we heard right in the beginning was that in contrast to many other countries and territories, the protections for academic freedom are embedded in our collective agreements. And on the whole, we heard that this is really a very positive thing. It means that academic freedom remains alive. It is there to be negotiated. It's there in our collective agreements. It is there to be negotiated, refined, expanded on through collective bargaining, through grievance and arbitration. So that was one of the it seemed to me, important things we heard. But we also heard that there are challenges. Across many years, there has been an inconsistent body of arbitral evidence. Arbitrators seem to fail to understand, or many arbitrators do fail to understand or perhaps appreciate the unique nature of the academic workplace. We also heard of some recent challenges. Employers, for example, redefining critique, part of intramural academic freedom, as incivility and disciplining academic staff for that. Also, academic staff, we heard, have been disciplined for extramural speech that is said to cause reputational damage, and this might come about with somebody's opinion on a blog post or an article that a newspaper or whatever that causes some form of outrage. We heard then these kinds of challenges, and we also heard some responses. One of the first things that was talked about was the need to educate arbitrators. And hopefully, publications from this conference may go some way to do that, and others may have ideas about other things we might do. Clearly, as part of that education, we need to articulate why extramural and intramural expression are key to academic freedom. We also had some practical advice, or we heard some practical advice for academic staff associations who might be looking to redefine or work on their academic freedom language. And one was, when you're looking at your language or negotiating language, was to avoid modifiers. Reasonable, responsible, really they become, as I think Sarah Godwin said, ways of backdoor slapping at academic freedom. The other thing academic staff associations should do is to ensure that all 4 pillars of academic freedom are included in collective agreement language. Finally, yesterday, we heard an impassioned call to create a new coalition of post-secondary education workers. This might be to fight back against the trucker protests, but probably not. And indeed, it might be to more likely to combat the ongoing commercialization and corporatization of post-secondary education. And those were just a very brief and very small slice of what we heard yesterday. And with that, I will turn it over to Bill Bruno, a member of the Harry Crowe Foundation Board, and our Vice President, I might say.
Bonjour à tout le monde. C'est un grand plaisir de vous accueillir à cette séance du colloque Harry Crowe. On entendra ce matin plusieurs collègues très expérimentés dans les domaines du droit de personne, la liberté d'expression et la liberté académique. Et sont arrivés, je pense à de toutes petites biographies de ces 3 personnes. Et il faut annoncer tout de suite que la 4e personne, Andrew Eamon, ne pourra pas participer ce matin à nos travaux à cause de circonstances imprévues. Mais avec nous ce matin, il y a Faisal Baba, qui est professeur agrégé à l'école de droit Osgood Hall. Il est bien connu comme chercheur, écrivain, comme plusieurs de nos conférenciers. Il a exercé en plus à tous les niveaux du système des tribunaux canadiens et y compris la Cour suprême du Canada. Donc toute une richesse d'expérience. Ensuite, nous entendrons Jamie Cameron, qui est professeur émérite à l'Osgood Hall Law School. Elle a enseigné et écrit sur des questions de droit constitutionnel et public, notamment sur la Charte des libertés et droits et la liberté d'expression et de la presse, la liberté académique, le droit constitutionnel et le droit pénal, et elle s'est intéressée aux bibliographies judiciaires. Elle est l'auteur de nombreuses publications et a dirigé d'autres. Elle est actuellement membre du conseil consultatif du Centre for Free Expression et participe aux travaux du Harry Crowe Foundation depuis quelque temps. Et enfin, en troisième lieu, Peter Jacobson, qui est avocat et conseiller juridique. Il connaît bien les problèmes soulevés hier et qui seront soulevés aujourd'hui par le problème et les principes de la liberté académique. Il a offert depuis de longues années à l'ACPU des conseils juridiques précieux et bien utiles. Et cela depuis au moins 30 ans, je crois. Alors, on passe tout de suite à notre premier conférencier, Faisal Baba. À vous la parole, Faisal.
Hello, hi. Yeah, thank you. I'm very glad to be here and participating in this discussion. I'm looking at the question, does the right to be free from discrimination operate as a legal limit on academic freedom? Anti-discrimination protections are contained in human rights legislation that is considered quasi-constitutional and which govern the university's treatment of its students, staff, and faculty as an educational service provider and employer. And the Human Rights Code has been incorporated into university EDI policies. People who belong to protected groups have a right to be free from discrimination and harassment in the receipt of services, including educational services. Discrimination is understood to mean not only being subjected to slurs, insults, epithets, but also to not having to function or operate in an educational environment that tolerates discrimination. And so this means that students have a right not to be subjected to derogatory or stereotype-based treatment, slurs, epithets. It also means that the university's obligation goes beyond simply addressing that kind of behavior. But it doesn't mean that the university is expected to control the behavior of all actors. And so what you're left with is a delicate balancing act with pressure from inside the university as well as outside the university that can be immense. And it can place intense demands upon the university to act. I myself became involved in one such example in June of 2020, about a week after the murder of George Floyd, when I participated in a debate online at Ryerson about the IHRA definition of anti-Semitism, in which I argued that definition poses a risk to academic freedom, because it applied a dangerously broad and unwieldy set of examples to an imprecise and misleading definition. Lots of credible people agree with that argument. I don't need to go into detail about it. I warned that this definition was already putting a chill on pro-Palestinian speech and threatening academic freedom. We could see this in Europe. We could see this in some US states. And indeed, we saw this happen at the University of Toronto with the Azarova affair, which hadn't yet happened when I was making the statement. Okay, 2 weeks after that debate, B'nai B'rith, a national civic Jewish pro-Israel organization, sent the president of York University a letter demanding that I be banned from teaching human rights. And its CEO published a petition that was mailed out to countless Jewish Canadians, unsuspecting Jewish Canadians, including the moms of at least a couple of friends of mine, who learned that there was this terrible anti-Semite teaching at Osgoode, poisoning the minds of Osgoode students. Michael Mostyn asserted that I was unfit to teach human rights because I treated hundreds of thousands of Canadian Jews as Jewish supremacists because of my critique of Zionism. Okay, I didn't call hundreds of thousands of Canadian Jews Jewish supremacists. I articulated a critique of a doctrine of Jewish supremacy that I said was integral to the policy of Zionism that was being implemented by the state of Israel. At the time, I guess I was certainly not the only one saying it, but at that time, Human Rights Watch, Amnesty International, B'Tselem, and Yesh Din hadn't yet come out with reports saying that. Since then, they have. But nonetheless, the president of the university was not going to succumb to the pressure. Human rights is my area, and I have tenure, and there really was no basis for the request. And she communicated that to B'nai B'rith, but what she didn't do was communicate that publicly, which was the realm in which this discussion was occurring. There was pressure. Independent Jewish Voices had put out a letter to President Lenton calling on her to denounce the smear. My retired colleague, my esteemed retired colleague, who's here, published an opinion piece calling on President Lenton for her failure to provide an open and timely response to the attack on me. And the truth of the matter is that the university was not, and still actually is not, prepared to publicly address this issue, to publicly tell B'nai B'rith that their request was preposterous, ill-founded, in bad faith. The university didn't even have to align itself with the content of my speech in order to do that. But they wouldn't do it. The president would not do that. And she told me that personally. What does this mean? Well, one way that I understand this is that when the university is informed about hurt feelings and allegations of discrimination, the universities now understand that academic freedom is not a perfect defense. It's not an excuse to turn away, and it's not a shield for allegations of on-campus or even arguably off-campus activity by faculty members. My comments had been made off-campus, but I was now poisoned because of that. And so what we have is the fact that academic freedom may need to accommodate anti-discrimination law. It's a careful balancing act, and I don't know that universities are well equipped to do it, but that is the reality. Okay, in their 2017 book, Free Speech on Campus, constitutional law professor Erwin Chermaninsky and senior university administrator Howard Gilman argue that if universities censor or punish the expression of ideas or allow intimidation or disruption of those who are expressing ideas, they are going to undermine the core function of the university, which is to promote inquiry, discovery, and the dissemination of new knowledge. They recognize that safe and inclusive learning environments are important, but that can't justify the restriction of ideas. This is where I think we have to land, recognizing that safe space is not a joke, but also recognizing that knee-jerking to censorship is not an appropriate response. It doesn't do anybody justice, let alone, in particular, and fundamentally, it doesn't do the university's mandate justice. The educational mission must be about opening students so that they may encounter knowledge. And sometimes opening means destabilizing. So, in my case, maybe that means letting Zionist students hear non-Zionist, even anti-Zionist perspectives. Again, the Azarova story tells us about the resistance to that possibility merely occurring. Legal scholar Jeremy Waldron has noted in the New York Review of Books that, quote, making students safe for ideas is not the same as pacifying them or requiring them to sit still in silence and just listen when hateful ideas are expressed. The stakes are high, and this is not a game. If civic engagement on campus is what we want, especially outside of the classroom, then we have to accept that it's going to be noisy. Waldron here is pushing back on the idea that counter speech is a threat to free speech, which is becoming quite popular. Tom Cromwell subscribes to this view as is reflected in two of his reports. And it's important to remember that protest and condemnation is part of the free exchange of ideas. Even B'nai B'rith has the right to express themselves in relation to my speech. I would never try to muzzle that organization, even though I do believe they need to be quiet. So while I said that academic freedom may need to accommodate anti-discrimination law, it's also a two-way street. So anti-discrimination law, which advances one charter right, that is the right to be free from discrimination, must sometimes yield to another charter right or other charter rights, in particular freedom of expression. So I wanted to talk about a few Human Rights Tribunal of Ontario decisions that actually wrestle with this issue. So the tribunal has at times been called upon to exercise its jurisdiction over universities and to sanction those who were expressing themselves in the function of their academic role. And so it has raised challenging questions for the tribunal. The tribunal has said, in a case involving a Catholic university chaplain who was running an international volunteer placement program and was heavily criticized by academics in the sociology department who described the politics of the program as anti-abortion and far right. And the chaplain said this was an attack on his religion and filed a discrimination claim with the Human Rights Tribunal. And the tribunal concluded that the case had no reasonable prospect of success because it found that it was what it was truly about was the expression of political opinion and hurt feelings, and that there was no hook to discrimination, even though there was a severe critique of religion. The tribunal reasoned that critique of religion is part of a free society, especially in the university context. The chaplain was a public figure and was open to critique. And in this reasoning, the tribunal laid down some dicta that has been repeated over the last 10 years since this decision was released. The decision, by the way, is called McKenzie and Isla, the 2012 decision of the HRTO. And the adjudicator wrote, "It's well established that courts and tribunals should be restrained in intervening in the affairs of a university in any circumstance where what is at issue is expression and communication made in the context of exploration of ideas, no matter how controversial or provocative those ideas may be." And he goes on to conclude, "It will be rare," and this is the part that has been repeatedly quoted in subsequent decisions, "it will be rare for this tribunal to intervene where there are allegations of discrimination in relation to what another person has said during a public debate on social, political, and or religious issues in a university." And that has been repeated in a subsequent case in 2013, a case called Marceau, where the university hosted a conference where a paper was presented, and in that paper, the N-word was used. And the scholar who used the N-word articulated a defense of the use of the N-word, discussed the benefits of slavery, criticized affirmative action, and stated that veganism causes subtle mental retardation. An attendee of the conference complained about the university and brought an application against the university for having facilitated the transmission of discriminatory speech and ideas. And again, the HRTO found that the claim had no reasonable prospect of success. This is an early dismissal in the process without even getting to the merits of whether it's discrimination. And that is because the HRTO said, based on the earlier reasoning, that the content of an academic paper does not fall within the meaning of services for the purposes of the Human Rights Code. It's beyond the jurisdiction of the tribunal. They will not even have a look at it. The Human Rights Code does not apply. In another interesting case called Katenji and Ryerson University from also 2012, a master's student who was researching ethical veganism alleged that she experienced discrimination when she encountered severe critique and resistance to her ideas by her supervisors and other scholars who were reviewing her work. They were vicious, and they blacklisted her, she alleged, simply because of her belief in the equality of animal and human life. One professor accused her of being a racist for analogizing the suffering of animals with the suffering of racialized persons. Fascinating issues. But the tribunal, again, applied the McKenzie rule to say, Human Rights Code does not apply to academic work. Quote, academic criticism of a person's scholarship will not constitute discrimination simply because it relates to a student's personally held values or beliefs. In other words, it's not discriminatory to critique the articulation of a personal belief. The adjudicator did note, however, and this is worth mentioning, that it is possible, I'm quoting here, it is possible for an academic evaluation or assessment to be discriminatory. For example, if an applicant can establish that her academic work was evaluated differently from others and that a code-related ground was a factor in that evaluation, there's a basis for discrimination. Similarly, the code may apply to comments made in the course of an academic evaluation. So any of us who teach ought to be thinking about that, careful about the kind of feedback that we give and the kinds of comments that are made in the course of evaluating students, because that can constitute discrimination. I mean, finally, in a case that kind of circles back to the Israeli-Palestinian conflict, which does seem to dominate a lot of this issue. A case decided just less than a year ago by the Human Rights Tribunal called Hart and McMaster University, in which a Jewish professor who alleged a long history of anti-Semitism at McMaster based on that university's hosting of Israeli Apartheid Week events. And his argument was essentially that the very content, the very premise of this event is the comparison of Israeli policy to apartheid was inherently anti-Semitic. And he argued that the university had a duty to ban it. Again, the HRTO found would not go to decide the issue on the merits, and it found that the application had no reasonable prospect of success, and actually pointed to a 2013 case in which the sort of flip side had happened, where Carleton University had actually banned some of the Israeli Apartheid Week posters, and the Students Against Israeli Apartheid had brought a complaint to the HRTO. And again, the HRTO said there, it's not our jurisdiction, this is a political dispute, it doesn't have a connection to the code. Okay, there must be a limit to this rule that the HRTO is applying. And I couldn't help but think about the Trump shithole country example and wonder if the tribunal, if there was an analogous statement to that, whether the tribunal would continue to decline jurisdiction. Okay, so some takeaways. That I want to say the decisions of the HRTO do not determine everything for universities, especially where we see the HRTO is making jurisdictional decisions about its jurisdiction. It's essentially punting on whether to decide the tough questions. Nobody wants really to decide competing rights questions unless they have to. So what the HRTO does ultimately say about the meaning of discrimination is relevant, but what it does about jurisdiction is not that determinative for what universities can do about their policies. As of now, universities all apparently have different ways of defining academic freedom and respond to challenging issues in their own ways, often without considering how others have done it before. So former Supreme Court Justice Michel Bastarache has actually highlighted that issue in his report. Perhaps that's been discussed already at this conference. He notes that there's a lack of consistency and recommends that working definitions be developed. I think that's not a bad idea. So I would just conclude by saying when it comes to legal limits on academic freedom, and in terms of looking at anti-discrimination law as a potential source of limit, I actually think the limit is barely noticeable. I think the limits when it comes to discrimination come from places outside the law. They're coming from interests that have more to do with the growth of universities, financial considerations, et cetera, rather than the noble principles or the avoidance of actual legal liability. So, and finally, I agree with what has also been said, that it will be for faculty associations to ensure that the academic freedom protections remain in collective agreements, and to find ways to strategize and bargain for more robust, more specific guarantees, and to put resources into test cases. My own grievance was abandoned, essentially settled on unfavorable terms because my union is tiny and nobody, including CAUT, would support them financially. So I think we need some solidarity, and we need to think about ways to come together to put forward test cases, because the question of what does it mean to promote academic freedom, which is what was in my collective agreement and is my understanding one of the strongest provisions in the country, we will not know, at least this time around, what that actually means. And so if language like that is to have any meaning, we need to be able to challenge it and bring it to adjudication and get decisions. Okay, thank you for your time.
Thank you very much, Faisal. We're all going to have to save our questions, which will be boiling to the surface about now, till we've heard everybody on the panel. And so with that, I'd like to turn right away to Jamie Cameron.
What I'd like to do this afternoon is turn attention to one of academic freedom's cornerstone principles, and it's the one that was the inspiration for the 1915 Declaration, and that is freedom of extramural expression. And it's, I guess it's a good fit to some extent with Faisal's presentation and his experience with York arising from his participation in a Center for Free Expression panel discussion. So to some extent, extramural expression is what I call academic freedom's problem child. And I'll explain why. So one reason is, and I'll just back up to say what we're talking about here, obviously, is expressive activity that takes place away from the university and the job site. So by definition, one of the problems with it is that by definition, it's a little bit removed from or distant to the core of academic freedom, which I think we can agree are the activities of research, teaching, and intramural life. So extramural expression takes place a little bit away from that. That's one reason it can be difficult to square with academic freedom. A second reason is that freedom of extramural expression confers, a kind of impunity from or non-accountability to the employer for any number of interventions in the public domain, no matter how tangential or unrelated they might be to discipline or expertise, no matter how inappropriate, unacceptable, or even appalling. And as we well know, academics are far from immune to the temptations of social media, where anyone can essentially pop off as impulsively and unwisely as they like. And there are numerous instances of social media blogs, tweets, etc., giving rise to serious questions of academic freedom and freedom from reprisal by the employer. So there's serious issues at stake with extramural expression. So today, in saying a few words about it, I only have two objectives. The first is a bit more descriptive, and it's a bit of a refresher of the key milestones in thinking about extramural expressive freedom over the years. And the second is to explain at least a little bit the relationship between expressive freedom and academic freedom, at least as I understand it. And so before going further, I just want to give a little bit of a shout out to Mark Gabbert. I see that he's on the call, and I just want to give a little shout out for a very fine article he wrote that's called Academic Freedom, Freedom of Expression's Vulnerable Child. So I think Mark and I conceptualize it a little bit differently, but we substantially agree on the issues and how they should be addressed. So turning to the milestone lesson, really all I want to do here is draw your attention to 3 dates which mark developments in the status of extramural expression as a component or element of academic freedom. So first and foremost, of course, is the 1915 Declaration. So this, of course, is the landmark that marked the introduction of academic freedom's central principles. And this genesis in the dismissal of academic staff who'd publicly criticized university founders, who were typically business capitalists, railroads, etc. 2 points about the 1915 principle and what it says in particular about extramural expression. First of all, the 1915 Declaration said that academic staff should not be banned or barred from engaging in debate outside the university, and that this participation should not be limited to their areas of expertise. And finally, nor should academic staff be deprived of their rights as citizens, their rights of free expression as citizens. So that is the basic principle of freedom of extramural expression. And then the second point, of course, is the caveat that was attached to that. So extramural expressive freedom, was also based on an obligation to avoid, and I quote, hasty or I'm going to move, sorry, I got a bit distracted there. I'm going to move to the third milestone, which is actually the 1970 statement and interpretation. But before doing that, I just want to pause and flag Harry Crowe, flag and honor Harry Crowe, the namesake of the conference, and how the Harry Crowe incident in 1958 actively prompted Coutts' involvement in academic freedom. So that's clearly the big milestone for Canada. But just sort of returning to the narrative and picking up with extramural expression, I want to turn to the 1964 AAUP statement and the 1970 interpretation. And these refinements arose from two really celebrated cases in academic freedom. I'm not going to go into details. Many of you will know the names. The first one is Leo Koch, and the second one is Angela Davis. And the key development here is the introduction of a standard of dismissal for extramural expression. And the standard that they came up with in the statement of 1964 and the interpretation of 1970 is unfitness for office. In other words, academic staff cannot be dismissed for extramural expressive activities unless those activities render the staff member unfit for office. So I think, again, that's a fairly high threshold. And in proposing that standard, it was observed that extramural utterances, quote, rarely bear upon the faculty member's fitness for the position, unquote. So I'm going to pause. I'm finished with my milestone portion. And I'm just going to say that on its face, this contemplates a fairly robust form of protection for extramural expression. But as we all know, the questions and controversies continue and, have escalated with the rise of social media. So one of the key issues that continues to generate discussion and trouble scholars is conceptual in nature. And that's the question whether extramural expression is really about expressive freedom, or is it instead about academic freedom? Is it about those citizenship rights, or is it about something to do with academic freedom? Is it one, the other, or both? And so to give a very short answer to that question, I'm going to take the easy way out and say that it's a bit of both, or I shouldn't say a bit of both, it's both at once. So first, as to academic freedom, I guess I would say that principally, and whether it's scholarly in nature or not, extramural expression is conceptually part of academic freedom. And the reason I say that is that the internal and external elements of academic freedom are indivisible. And that is why, in my opinion anyway, the external must be recognized as an element of academic freedom, even when it's non-academic in content. To explain a little bit further, the first reason is because you are not truly free inside the university if you can be dismissed, suspended, reprimanded, etc., for what you say outside the university. So freedom is a promise that cannot be made contingent in that way. And to uncouple the external and internal elements of academic freedom risks self-censorship and a dampening of the spirit of inquiry. The second reason is closely related, and that is that you can't plausibly have a double standard on this issue. You can't have a double standard that would confer academic freedom on research teaching and intramural life inside the university, and at the same time expose staff to consequences for saying the same things about research, teaching, and so forth outside the university. It just doesn't work conceptually, principally, or on the ground. So the bottom line is that academic freedom protects expressive freedom and extramural expressive freedom for academic freedom's sake. And so my conclusion is that freedom of extramural expression is about academic freedom. But I want to just get back to freedom and make that connection as well, because there is a central premise of freedom at issue here, and it's common to expressive freedom and to academic freedom. And that's the very basic idea that freedom of expression necessarily includes the good, the bad, the indifferent, the outrageous, and on and on. So to those who worry about decorum and the professionalism of the academy, my answer would be that freedom that is abused or exceeded or disrespected by some academics when they're engaging in extramural expression is simply the
Peter, in hopes that the system is kinder to you, would you mind unmuting? And we'll have a look at your face too. There you are. Welcome to the conference, and let's hope that things go a little bit better for you and that the internet weather is better wherever you are. Over to you, Peter. Thank you very much.
Well, thank you. I've got to say that if I were to step outside into the snowstorm, I would be physically frozen, but
Right.
At present, I'm not electronically frozen. And I want to say good afternoon to everyone. I'd first like to thank the organizations of the Harry Crowe Foundation for organizing this conference and giving me the opportunity to speak. But I have been asked in a mere 15 minutes to address defamation and academic freedom and the use of defamation suits as a tool to stifle expression and academic freedom. Those of you who were able to attend yesterday know that generally academic freedom refers to the freedom to teach, discuss, research, and publish works without institutional censorship or other unreasonable interference. Without academic freedom, post-secondary institutions cannot achieve the goals of disseminating knowledge or fostering independent thinking and expression. But with any freedom comes limits. Tell the truckers that. For example, academic freedom does not protect hate speech or defamatory statements. And this is very important to understand, there is no specific defense to a defamation claim arising out of the fact that it was written as an exercise or purported to be written as an exercise of academic freedom. In other words, the general laws of libel and slander or defamation apply. Defamation claims test the core principles of academic freedom, including the right to state unpopular opinions, even those that might offend the listener or the reader. These claims also test the limits of colleges and universities' authority and discretion in both formal and informal settings to make judgments about the competence and qualifications of the faculty and students. As you know, defamation lawsuits have been used to intimidate academics and to stifle free inquiry. Let me give you an example. As you know, scientists and academics are used to defending their theories, methods, and results in the classroom and at conferences and in peer-reviewed publications. But Peter Cohen, an assistant professor at Harvard, had to defend his research through a libel after being sued for libel. And the suit was brought by High-Tech Pharmaceuticals, a manufacturer of dietary supplements. They sued Cohen and his 3 authors based on a peer-reviewed scientific article about the chemical compositions of certain weight loss supplements. The jury ultimately ruled in favor of Dr. Cohen, and thus he was able to beat back the libel claim. Now, this would seem a successful outcome, yet it came at significant personal cost for Dr. Cohen. Since the suit arose out of his employment as a faculty member, Harvard Medical School stepped in to defend him. But the attorneys were hired under Harvard's insurance, and the insurer had agreed to cover only up to $5 million in damages at the time of filing the suit. High-Tech's demands were much higher. In addition to the financial burden and uncertainties, Cohen lost valuable time and energy that he could have devoted to his research. Additionally, as required during the lawsuit, he had to provide High-Tech with copies of his research material and notes, as well as his correspondence with the publisher and his colleagues about the research in question. While ultimately successful in court, High-Tech's lawsuit effectively sent a warning to other academics that publishing and promoting their research could result in defending their work in expensive, time-consuming legal action. In fact, High-Tech's CEO is attributed with a comment that he hopes that the long and costly legal battle will scare away other academics from investigating the supplement industry. So you can see that and this is what we call chill, libel chill. It's alive and well, and it's an effective weapon against anyone because of the time and effort and expense that you're going to spend defending yourself. Now, as you know, defamation suits against university faculty and staff can arise in contexts other than academic publications. For example, in Canada, academics have attracted defamation lawsuits regarding comments they've made on social media. I'm referring to the Dr. Gill case. Gill filed a $6.8 million libel suit last year against 23 of the detractors, including a former president of the OMA, claiming they had maliciously sullied her reputation for saying that what she had stated was incorrect and had no scientific basis. And then, you know, I'm sure people know about the Galloway case in British Columbia, where the former creative writing chair at UBC claims he was falsely accused of sexual physical assault. And the BC Supreme Court judge said a defamation filed by him against the woman he claims falsely accused him of sexual and physical assaults can continue to trial. Also, internal faculty reviews and discipline may give rise to defamation claims. For example, you may be aware of the lawsuit launched by Jordan Peterson against Wilfrid Laurier University. Laurier teaching assistant Lindsay Shepard showed her class a clip of Peterson talking about gender pronouns. 3 Laurier staff members held a meeting to discipline Ms. Shepard for this event. She secretly recorded the meeting and provided the recording to the media. Peterson then brought a defamation suit against the university and the 2 faculty members for comments made about him during the discipline hearing, which he characterized as malicious and designed to specifically damage his reputation. This case is ongoing. Another example are the Me Too allegations that we see. We've seen a court find against an academic who accused someone of sexually harassing her when she was a law professor at the University of Windsor more than 6 years ago. The court ultimately awarded and this was not a Canadian court, this is a Trinidad and Tobago court, but they awarded the plaintiff the equivalent of more than $100,000 in damages because of what the professor told the employers after he left the university. So how can you exercise academic freedom while avoiding a defamation suit? The first step is understanding when the courts will consider a statement to be defamatory. In Canada, it's relatively easy for a plaintiff to establish defamation. The plaintiff just needs to prove 3 elements. 1, the publication or dissemination was by the defendant, and that it was made to a third party, meaning someone other than the plaintiff. Publishing statements in a academic journal would qualify as making a statement to third parties. The second is you have to be able to identify the plaintiff. Sometimes you won't explicitly name the plaintiff in the publication. However, there still may be reasonable identifiable attributes expressed that can give rise to the plaintiff having been identified. So you might not use the plaintiff's name, but if you refer to their job title and specific research, they're going to be identifiable at least to their colleagues, who are probably very important to them, and others who know about those details. So what we sometimes do in libel, when we're doing a vetting of something that you want to publish, we might consider removing any identifying information, because it really might not matter who the person is. What matters is what is being said, or the background that you want to get to. And the third is that it has to have a defamatory meaning. And of course, a statement is defamatory if it would tend to lower the reputation of the plaintiff in the eyes of a reasonable person. This is usually not too hard to establish, but for example, with changing mores in society, there are things that maybe 20, 30, 50 years ago would have been defamatory, but today would not be. And if I can express, for example, it might have been defamatory 50 years ago to say somebody was gay, whereas today that probably would not be seen as defamatory in most circumstances. So what are the defenses? Well, if a plaintiff establishes defamation, the defendant can still avoid liability by raising one of the defenses. And defamation litigation often focuses on whether the defendant has a valid defense. So when writing a paper or preparing a talk, you should be careful to frame your statements so that one or more of the defenses would apply. The first one, of course, is truth. You can avoid liability if your statements were substantially true, but it's up to you to prove that the statement is true. So when writing a paper or preparing a conference talk, be sure to fact check any real-life examples you are using. In practice, proving a statement is substantially true in court can often be difficult. We often avoid pleading this defense because it can lead to more damages being awarded to the plaintiff if you fail to prove truth. The next is qualified privilege. This is what they call the duty and interest defense, and it applies where a speaker has a duty or an interest in making a communication to a recipient, and the recipient has a corresponding interest or duty to receive that communication. Courts have considered different communications in the academic context to fall within qualified privilege, such as communications among members of a faculty search committee, internal communications about faculty performance, rehiring and tenure, faculty performance evaluations, faculty research misconduct proceedings, and internal communications about student academic progress and discipline. The essence of this is that there has to have been a duty to report the information and a legal or social interest in receiving the information. So let me give you a really pedestrian example. Let's suppose you have somebody in your office who is a new clerk who's been stumbling around. You go out and you smell what you think is alcohol on his breath, and you report that to human resources. If it turns out that in fact you were wrong, the person had a balance problem, inner ear problem, and they had had strong mouthwash, which you mistook for alcohol, because your statement to the human resources people was you have a duty to report this kind of thing, and you had a sincere belief that it was true. If you've only sent that to the people who needed to receive it, that is the human resources people, you will have a valid defense, absent any malice. I'm going to leave malice out for now. But let's suppose you thought, gee, my memo is pretty interesting, and I wrote it in a very amusing way, so I'm going to send it around to everybody in the department. You've just lost your defense, because those people in the department have no legal interest or moral interest in receiving that information. So that's how duty and interest works. So in the Jordan Peterson example, since the comments of the staff members were made in the context of a university disciplinary meeting, they might also be covered by qualified privilege. The question would be whether the three staff members had a duty to hold a disciplinary meeting for Ms. Shepard. For instance, if the student had complained about the clip that Ms. Shepard showed her class, there may have been a duty to do so. However, As I said earlier, a plaintiff can overcome qualified privilege if they can prove that the defendant's dominant motive for making the statement was malicious, or that they had another reason, is what the courts would say, if the dominant motive was something other than transmitting the information, but you were for another reason trying to damage the plaintiff. The next defense is fair comment. And we've all heard about fair comment. Oh, this is fair comment, that is fair comment. Let's talk about what you have to do in order to ensure that you can successfully raise the fair comment defense. First of all, the comment has to be a matter of public interest. And the courts have defined public interest in a way that most topics of academic interest will be seen as matters of public interest. So you're very likely to get over that hurdle. The second is the comment must be based on facts that were either included in the publication or known to readers. Now, what this means is that for the most part, it's wise to put the facts, the true provable facts upon which you're basing your comment into your article or into your talk. And the reason for this is to allow the receiver of the information to evaluate themselves whether they agree with that comment or not. For example, let's say that someone says that I am an incompetent lawyer, and the true fact that they put forward, which isn't true, by the way, is that I'm always late for court, and I do not return my clients' phone calls on the same day. Now, many people would say, that doesn't mean he's not a competent lawyer. Others might say, it means he's an incompetent lawyer. So you need to put in the substratum of true fact that you can prove, and the comment has to be something that could possibly be supported by those true facts. I just got to notice that I've got to speed up a bit, and I will. And the third is that the comment is recognizable as comment. Be careful not to frame your comments as objective statements of fact. The comment satisfies this objective test, must have satisfied this objective test. Could any person honestly express the opinion on the proved facts? So it's got to be, your opinion has to be related to those true facts in some way, but the courts are not going to come along and say, oh, we don't like that comment, or we don't think that comment really follows. You will get the fair comment defense absent malice again. If you've put in the substratum of the true fact, or if the true fact is notorious, which would be another way in which the reader could determine whether or not the information was the comment was, in their view, fair. The last defense I'm going to deal with is responsible communication on matters of public interest. And it's a defense that's primarily used in the journalism context, but it's applicable to academic publications as well. Academic publications and speech as well. Again, it has to be, the comment or the statement must be on a matter of public interest, and that it was responsible. And the reason for this is to allow speakers, communicators, to make statements that are wrong, but they've done everything reasonably possible to get it right. And this is a defense that has caused academics and journalists and other writers to be super careful about making sure that, for example, they go to the person that they're writing about and get their opinion on what they are writing. I'm going to say that you didn't do proper research on X and Y. You should be getting a hold of this person and saying, look, this is an allegation I'm going to make against you. Give me your thoughts. And it may be that the person will get back, and this has happened, certainly in the journalistic field. People get back and say, look, here's my proof. I'm not wrong. So it is an opportunity to get it right. So there are a number of criteria that I don't have the time to go through with respect to that. But let me just finish off with best practices when faced with a defamation claim. If you get a letter from a lawyer saying, or anyone saying that something you've written is defamatory, and if they decide to start a lawsuit, you know that you're going to have to back up what you've said with evidence. So make sure that you've kept the evidence that you're going to base your comment or your statement on. And any records that you have should be maintained for at least 2 years. If you're writing a controversial article, maintain that for at least 2 years, because you may need that evidence as proof that what you said was truth. And remember that social media can also be a place where you can get into trouble with defamation. One of the biggest problems that's arisen has been the informal nature of social media. People will send a text to someone else saying, "Hey, I think we've got him. I think we've finally proven that he's a crook." Well, that's going to be producible. You're going to be required to produce that statement on discovery. So be very careful. Many of the comments that we used to make around the coffee cooler are now unfortunately put into writing as we email each other, text each other, etc. Be very careful about what you put into those communications, because it's producible. And if a court sees that, oh, you wrote to some other colleagues and said, "I think we finally got him," the court's going to say, "Well, wait a minute. Is that your role? Is your role to go and get that person? Or is your role to be objective and fair in what you've written?" And of course, it's the latter. So if you get a notice of libel or a letter telling you that you've defamed somebody, you can know that academic staff accused of or experiencing defamation and carrying out their academic activities should consult in the first instance with their academic staff association, and that the academic staff association should seek legal counsel. The defense of academic freedom should not be borne by the individual academic staff. Where academic staff are accused of defamation in legal proceedings, the institution should provide a defense and legal representation. And this was a statement approved by the CAUT Council in April 2018. That's all nice, and that is correct. But if there's a circumstance where you're not getting representation through them, just make sure that you've got it in place, that you've got legal defense in place. Sometimes the person complaining will be seeking a retraction or an apology or words that can get you out of the difficulty, but at least make sure that you've got legal representation. Remember that when you get sued, everything that relates to that lawsuit that you have in your possession or control is producible on discovery, has to be given to the other side, unless, of course, it's a privileged document. Solicitor-client privilege, for example, would be exempt. But just keep in mind that you've got to produce what you've written, which is one of the reasons that you want to be very careful with what you put down on in writing to other people about the case.
We're short of time.
For example, in the Cohen case that I referred to, he had to provide the plaintiff, High-Tech, with copies of his research materials and notes, as well as his correspondence with publishers and his colleagues about his research. And so that's very, very intrusive and very, very unpleasant. Defamation actions are unpleasant by their very nature. They are time-consuming. They make you worry at night. And that's why keeping good records and having a good lawyer to defend you is crucial. Now, there may be a mediation. It may go to trial. I can't get into all of that in the time I've got. And I just want to make a very quick comment about anti-SLAPP laws. These are anti-strategic litigation against public participation. So strategic limitation against public participation gives the SLAPP name. And they these laws provide an affirmative defense to a lawsuit that is filed with the intent to censor, silence, or intimidate critics by burdening them with costly legal defenses. So it's really in a situation where they're saying, look, the reason that you're being sued is to shut you up. It's not because there's really a valid case against you. It's more to shut you up. These cases started in the beginning, or started with large forestry companies suing NGOs who are critical of their practices. And of course, it didn't take very long for the NGOs to risk going broke trying to afford the legal fees. So I can't get into all of the anti-SLAPP material that we've got here, but what the anti-SLAPP legislation does is it makes it very, very expensive for an unsuccessful plaintiff to bring an unmeritorious case against a defendant, and that would include, obviously, academics. I've been asked to wrap up, and again, I thank you for your attention, and if there are any questions, I hope to hear them later. Thank you.
Thank you very much, Peter. Jamie is back, and I'd like to invite her just to take a couple of minutes. Time is precious, but we need it to hear what happened next. So, Jamie, are you able to join us again?
Yes, thank you so much, and thank you for your patience. So I just finished saying that freedom of extramural expression is about academic freedom, but I was trying to go back to expressive freedom and kind of show the connection between theories of expressive freedom and theories of academic freedom. And basically, I just wanted to flag a very central premise of freedom generally, which is that there's a very high threshold of content neutrality, and that means that freedom of expression and freedom of academic freedom both include protection for the good, the bad, the indifferent, the outrageous, anything, any form of expression that's imaginable, and it can't be any other way. So where I think I got cut off was I was saying also that to those who worry about decorum and the professionalism of the academy, for those who can't or don't want to countenance, in particular, extramural expression that is extraneous to academic endeavor, my answer would be that the freedom that is abused or exceeded or disrespected by some is simply the price we all pay. The price we all pay necessarily and gladly for academic freedom exceptionalism. And by that, I mean a full and robust conception of academic freedom. So I endorse the suggestions that have been made by others to include specific protection for academic freedom, including extramural expression in collective agreements. And I just want to close with an important reminder of who we are and how we serve the public interest. And it's just a short quote by an academic who was absolutely pilloried by the public for some work she had done that went into the public domain. And her comment was that all academics have a duty to defend academic freedom, and especially to do so and defend the academic freedom of those they disagree with. And this is what she said, and I want to quote it because I think it's very powerful. And here it goes. When we identify an important question, but we decide to ignore it because we fear for ourselves, we are betraying the trust of society who gave us the privilege of doing such an important job, and we wrong all the people who fought for academic freedom and paid a very high price for it. We also wrong future academics because we teach them that being a coward pays more than being free. Okay, thank you, the end. Thank you for giving me the chance to finish off.
Welcome, everybody. Bonjour tout le monde. I'm Michael Link. I teach law at the University of Western Ontario. You may have seen me present on the first panel yesterday. I've been asked with great delight to chair this fourth and final panel for the conference. And the title of this panel is the future of academic freedom in law. And here we'll be exploring questions of the role of the Charter of Rights in protecting free expression, but more specifically academic freedom, and whether universities ought to be encompassed by the protections and obligations of the Charter, whether or not there might be support for enacting legislation in Canada that specifically protects academic freedom. Presently, there are only 2 statutes that I'm aware of, both in Saskatchewan, which mention academic freedom in statutory language, and neither of them actually are meant to protect academic freedom as we're discussing it during this conference. We'll also be looking at the future direction of the law as well. And like every other chair of these 4 panels, we're blessed to have a panelist full of accomplishments, and therefore I'm going to be very brief in my introductions to each of the 4, and I will each introduce them with their brief bio as I invite them to speak. But the first speaker today will be Louis-Philippe Lampron, who teaches law at Université de Laval in Quebec City. He is a full professor. His areas of interest are in fundamental rights, human rights and freedoms, cultural pluralism and the law, and in public law. So Louis-Philippe, I'm wondering if I can invite you to begin this 4th and final panel.
Thank you very much, Michael. Thank you for the CAU2 for the organization of the Harry Crowe panel. I'm really glad to be here. I'm going to make my presentation in French. And I'll try, it's kind of a running gag, but I'll try to speak as slowly as possible for the translators. I'm apologizing in advance because it's one of my main flaws. I'm getting enthusiastic and then I'm speaking like Speedy Gonzalez. So I'll try to keep it as slow as possible. Alors, bonjour tout le monde. Merci à Michael et à David pour l'invitation. C'est un plaisir de m'adresser à vous. J'ai malheureusement pas été en mesure d'assister à la première partie, mais j'ai assisté au panel qui nous a précédé et qui était extrêmement riche et intéressant. Là, je vois une main levée. Je ne sais pas si c'est une question ou déjà j'ai commencé à parler trop vite.
Non, allez-y.
J'y vais, très bien. Merci beaucoup. Alors, parler de la situation au Québec, en fait, en ce qui concerne la liberté académique, j'ai présenté dans une conférence il y a quelques années à Harry Crowe, et je fais partie de celles et ceux qui prétendent qu'en raison des similarités entre la liberté académique et la liberté de la presse, il y aurait un cas à faire pour être capable d'obtenir une reconnaissance constitutionnelle de la liberté académique comme un corollaire de la liberté d'expression, corollaire institutionnel, similaire donc au droit d'accès à l'information qui a été justement jugé comme étant une émanation de la liberté d'expression, parce que les universités comme les médias devraient être en mesure de contribuer à la diffusion des faits objectifs, fiables, dont nous avons toutes et tous besoin pour participer valablement à la société démocratique et s'exprimer avec une valeur ajoutée. Alors voilà où je loge au niveau juridique. Maintenant, on a un débat au Québec depuis 2000, les dernières années essentiellement. Plusieurs situations factuelles problématiques sont survenues en fait qui laissaient entendre qu'en raison d'une grande verticalisation des rapports hiérarchiques au sein des universités, il y a eu des collègues qui se sont ramassés en danger pour avoir fait leur travail ou carrément sanctionnés pour avoir fait leur travail ou menacés et non représentés par leur université, toujours pour avoir fait leur travail. Alors, on pourrait citer là, en rafale les cas Daniel Weinstock avec le gouvernement du Québec qui avait été désinvité à une conférence suite à une chronique là, d'opinion d'un chroniqueur de l'équivalent de Rebel News ou à peu près. Et donc, le gouvernement avait désinvité le collègue Weinstock. La collègue Chantal Pouliot et la collègue Marie-Ève Maillé, qui avaient été poursuivies, fait l'objet de poursuites judiciaires qui n'ont pas été représentées, sauf très tardivement par leur université. Donc, le support judiciaire dans des situations comme celle-là. Bien sûr, le cas du collègue Andrew Potter, qui a été également là, sanctionné pour avoir tenu des propos dans l'espace public. Alors, dans la foulée de ces éléments-là, il y a plusieurs dont je fais partie là, qui se sont tournés vers les universités pour peut-être appeler à une plus grande responsabilité de la part des institutions universitaires pour protéger la liberté académique individuelle, en fait. Parce qu'évidemment, dès qu'on parle de liberté académique, de liberté universitaire, il y a deux grandes composantes. Hein, je vous apprends rien, mais je le rappelle quand même. La liberté institutionnelle, hein, toute la garantie d'indépendance des universités par rapport au pluriel gouvernement, et bien sûr la question de l'exercice individuel de la liberté académique dans ses recherches et dans sa capacité à notamment diffuser largement et sans être inquiété pour des contingences doctrinales ou d'intérêt pour avoir fait son travail justement de recherche et d'enseignement. Bon. Alors, 2019-2020, le pendant québécois de l'ACPU, la Fédération québécoise des professeurs d'université, a lancé des travaux visant à élaborer justement un projet de loi cadre qui protégerait de manière uniforme la liberté académique au Québec. Parce que, et là je réfère aux travaux justement de Michael Link, évidemment encore aujourd'hui partout au Canada, et c'est la même chose au Québec, la principale source de protection de la liberté académique demeure les conventions collectives. Et ces conventions collectives-là, à tout le moins au Québec, la force des conventions collectives pour protéger la liberté académique, c'est à géométrie variable. Il y a des universités où la liberté académique est plus largement protégée que d'autres. Et dans la foulée de ces discrepancies-là, la FQPPU a mis sur pied un groupe de travail dont je faisais partie pour réfléchir à la possibilité de proposer au gouvernement l'adoption, à l'État donc du Québec, l'adoption d'un projet de loi cadre sur la liberté académique. Alors, la FQPPU travaille de son côté et en octobre 2021 va survenir une controverse qui a révélé beaucoup de clivages dans la société canadienne. Excusez-moi, ça a coupé. Est-ce que vous m'entendez toujours?
Oui, on vous entend.
Très bien. Alors, l'affaire Lieutenant Duval, où cette professeure adjointe associée, alors, elle n'est pas permanente à tout le moins à l'Université d'Ottawa, dans le cadre d'un cours, va prononcer le mot en haine à plusieurs reprises, donc ça va créer un tollé. Elle va être suspendue par l'université de manière temporaire, et donc, je n'ai pas besoin de vous rappeler les faits, mais ça a fait couler beaucoup d'encre au Québec, et ça a mené le premier ministre Legault, premier ministre actuel, à faire une sortie où le premier ministre Legault s'inquiétait de la protection de la liberté académique, en lien directement avec ce qui se passait, donc la mouvance qui ferait en sorte que certains mots ne pourraient plus être prononcés par des professeurs, si tant est qu'ils ne fassent pas partie du groupe auquel le mot est associé. Enfin, bon, je résume grossièrement, une thèse qui est en jeu dans ce débat-là. Et le premier ministre Legault va faire cette sortie-là, sortie qui va être jugée quand même assez inquiétante en raison justement du principe de l'indépendance des institutions universitaires. Hein. Et c'est peut-être la tâche aveugle du raisonnement. C'est sûr que de demander, il y a un paradoxe à quelque part, de demander une intervention législative pour protéger la liberté académique. C'est certain qu'il faut avancer avec beaucoup de délicatesse pour éviter une ingérence qui serait contraire à l'idée même de la liberté académique au sens institutionnel du terme. Bon. Et la sortie que le premier ministre Legault va faire, là, on est à l'automne 2021, moi, elle me semblait quand même assez inquiétante, justement en raison de ce paradoxe-là et surtout en raison du fait que ce qui menait le premier ministre Legault à s'intéresser aux menaces qui pèseraient sur la liberté académique, c'était quelque chose de très, très contextuel, voire de politique, et ça n'avait rien à voir avec en tout cas les menaces qui ont été soulevées depuis plusieurs années, voire décennies, en ce qui concerne justement les risques qui pèsent et le poids qui pèse sur les collègues qui vont aborder des questions socialement vives. Alors, dans la foulée de cette sortie-là, le premier ministre Legault, le gouvernement de la CAQ va mettre en place une commission scientifique indépendante qui va être présidée par un ancien politicien, un ancien ministre du Parti québécois, Alexandre Cloutier, avec un board quand même assez solide, là, avec notamment deux collègues là, que j'estime énormément pour leur indépendance d'esprit notamment, Yves Gingras et Chantal Pouliot. Alors, la commission va mener des travaux, des consultations, un sondage, etc. et va finir par rendre un rapport. Mais c'est certain qu'en raison du contexte où on va mettre en place la commission Cloutier, de la personne qui va assumer la présidence, qui est un ancien politicien, alors qu'on a des doutes sur les intentions du gouvernement en mettant en place cette commission-là dans la foulée toute particulière de l'affaire Lieutenant Duval, il va y avoir quand même des suspicions raisonnables en lien avec les conclusions auxquelles pourrait en venir la commission Cloutier. Elle va déposer son rapport à la commission Cloutier. Tout ça a été fait dans un laps de temps quand même assez court, mise en place au début de l'hiver 2021. Elle va rendre son rapport en décembre 2021 et elle va recommander une loi cadre. Bon, j'ai procédé à l'analyse du rapport de la commission Cloutier et il me semble que les recommandations de cette commission-là vont dans le sens de ce qu'on peut espérer, malgré le paradoxe dont je vous parlais, en raison avec le respect de l'indépendance institutionnelle qui vient avec la liberté académique, la liberté universitaire. Les recommandations du rapport Cloutier me semblent tout à fait conformes avec ce que souhaite et défend l'ACPU depuis plusieurs années. Alors, je vais faire un petit résumé là, des grandes lignes des recommandations du rapport Cloutier. Donc, recommande l'adoption non pas d'un énoncé de politique, donc quelque chose qui aurait une portée indicative, une portée non contraignante, mais carrément l'adoption d'une loi cadre. Donc, va dans le sens de du projet qui avait été déposé un an plus tôt par la FQPPU. Et à l'intérieur des recommandations, il y a 5 éléments, moi, qui m'apparaissent très importants et que j'aimerais qu'on souligne ensemble. Premièrement, la définition qui est retenue de la liberté académique par le rapport Cloutier est la même que celle qui est retenue par l'ACPU et qui est également intégrée dans la fameuse déclaration de 1997 de l'UNESCO. Alors, c'est une très, très large, très généreux là, comme définition de la liberté académique qui permet notamment la liberté dans l'enseignement, dans la recherche et également la capacité de prendre la parole publiquement pour critiquer sa propre institution. Alors ça, c'est quelque chose d'important. Deuxièmement, on va préciser une approche qui est dite, en tout cas que moi j'appelle une approche dite en spectre d'intensité, c'est-à-dire la liberté d'expression en vertu de la Charte canadienne. Là, il y a, quand on regarde le vaste éventail d'activités qui peuvent être protégées, il y en a qui se trouvent au cœur de la protection, puis il y en a d'autres qui sont périphériques. Et la conséquence de ça, c'est que si une activité expressive est jugée être au cœur de l'objet de protection de la liberté d'expression, bien, ça va bénéficier du maximum de protection offerte par cette garantie fondamentale-là. Et plus on s'éloigne du cœur, puis moins ces activités expressives-là vont bénéficier d'une forte protection. Alors, sur la liberté académique, c'est un peu la même chose. Tout le débat entre la liberté d'expression, on en a parlé là, dans le panel précédent, là, intramuros, extramuros. Alors, les commissaires suggèrent que le cœur de la liberté académique, ce soit l'expertise des collègues. Donc, quand on diffuse notamment des travaux de recherche scientifique, là, on est au cœur de ce qui justifie cette liberté institutionnelle-là, mais elle ne doit pas s'y limiter. Elle ne doit pas se limiter à la seule expertise, et ça m'apparaît être heureux, puisque trop souvent, dans les cas passés, bien, les administrations universitaires justifiaient des refus de prendre fait et cause pour des collègues qui étaient pris à partie pour avoir pris une position publique en disant « Ah, bien ça, c'est pas vraiment au cœur de votre expertise, donc nous, on n'a pas à nous en mêler. Là, vous êtes allé trop loin, donc vous n'êtes pas au cœur de votre expertise et nous, on juge que vous n'exerciez pas votre liberté académique. » Alors, les commissaires vont éviter ce piège-là en disant la liberté académique, bien, son cœur, c'est l'expertise, mais ça ne doit pas s'y limiter. Précision très claire, troisième élément dont je voulais vous parler, la fameuse obligation de loyauté. Qui, dans le secteur public, là, est, pour moi, là, on assiste à une dérive en droit public, en droit des rapports, en tout cas, en droit des rapports du travail dans le secteur public, qui permet justement à des institutions, des employeurs de sanctionner des salariés pour avoir pris la parole publiquement d'une telle manière qu'ils nuisent à ses intérêts. Alors, dans certains cas, on a reproché à des membres du secteur public, des agents de l'État, d'avoir critiqué l'institution publique pour laquelle on travaillait. Alors, là, ils viennent affirmer clairement qu'en raison de la conception large qui est retenue de la liberté académique, bien, l'obligation de loyauté ne peut pas être appliquée de la même manière en ce qui concerne le personnel. Donc, les professeurs et les professeurs, c'est ceux qui bénéficient de la liberté académique. Quatrième élément important, et vous voyez, je suis vraiment un fan du rapport de la commission Cloutier. Quatrième élément important, les bénéficiaires. Alors, qui bénéficie de la liberté académique? Bien, évidemment, pour la commission Cloutier, ce sont surtout les professeurs et les chargés de cours, puis toute personne qui fait de la recherche et de l'enseignement. Donc ça, c'est les principaux bénéficiaires de la liberté académique. Les étudiants bénéficieraient de la liberté académique dans la mesure où ils font de la recherche, donc étudiants gradués notamment, et souhaitent diffuser les résultats de leur recherche. Mais tous les étudiants ne bénéficient pas de la liberté académique lorsqu'ils sont étudiants. Ce dont ils bénéficieraient pour la commission Cloutier, ce serait de la liberté d'apprendre, qui se distingue donc de la liberté académique. Donc, c'est une distinction qui est assez intéressante. Et dernière suggestion là, qui est contenue dans le rapport Cloutier, c'est que la loi cadre qui protège la liberté académique oblige les institutions universitaires, donc d'enseignement supérieur, à prendre fait et cause pour les collègues lorsqu'ils sont pris à partie, notamment de manière judiciaire, là, pour avoir fait leur travail, pour avoir exercé leur liberté académique, qui, je le rappelle, ne doit pas se limiter à leur seule expertise. Bon, alors ça, c'est le rapport Cloutier, et ce rapport-là a été déposé en décembre 2021. Qu'est-ce qui a suivi de quelques jours ou quelques semaines le dépôt de ce rapport-là et qui fait en sorte qu'on a arrêté subitement d'en parler? Ben, c'est Omicron. C'est le variant, la 5e vague, etc., là, qui a fait en sorte que la proposition de la commission Cloutier elle a été un peu écartée là, de l'actualité. Mais là, comme on s'approche peut-être d'un déconfinement, là, si les camionneurs finissent par... voilà, enfin, on verra ce qui va se passer. C'est le printemps de tous les dangers. C'est le printemps de tous les dangers, parce que je suis fan de la commission Cloutier, mais il faut quand même se rappeler le contexte dans le cadre duquel le gouvernement Legault a mis sur pied la commission Cloutier. L'intérêt qu'il avait semblait politique et semblait donc dangereusement risqué en raison justement de l'ingérence potentielle qu'une intervention législative pourrait faire peser sur l'indépendance qui doit caractériser les rapports entre les universités et l'État. Alors, pour moi, la proposition qui se trouve au cœur du rapport Cloutier, elle est cohérente avec ce que l'ACPU défend, avec ce que la FQPPU a demandé par ailleurs. Et ce faisant, on se trouve à, sans l'enchasser dans la Charte québécoise des droits et libertés, par exemple, à avoir presque l'équivalent en droit québécois de ce que serait une reconnaissance par le truchement de la liberté d'expression, de la liberté académique. Il y aurait ce méta-principe-là qui constituerait le plancher en deçà duquel les universités ne pourraient pas aller en ce qui concerne le respect de la liberté académique, ce que je juge très intéressant. Maintenant, entre cette proposition-là, très forte, cohérente, respectueuse de l'indépendance des institutions universitaires et ce que le gouvernement pourrait vouloir faire de cette recommandation-là, il va falloir être très, très vigilant et aux aguets. Parce que ce n'est qu'en mettant en œuvre, pour moi, l'entièreté des recommandations de la commission Cloutier qu'on pourrait respecter justement cet équilibre des forces-là et arriver à une codification de la liberté académique qui ne mettrait pas à mal le principe de l'indépendance institutionnelle qui est au cœur de cette garantie fondamentale. Alors, voilà où nous en sommes pour l'instant. On imagine donc qu'il y a des élections au Québec qui se profilent là à l'horizon. Alors, est-ce que ça va faire partie là, des débats électoraux? Il va falloir voir, mais le rapport est une bonne chose. Reste à voir maintenant comment est-ce que le gouvernement va se l'approprier. Alors, voilà pour ce que j'avais à dire. Peut-être que j'ai trop parlé. J'espère que non. Je me suis enthousiasmé. J'ai tenté de garder un rythme compréhensible. J'espère que les traducteurs ne m'en veulent pas. Merci de votre attention.
Louis-Philippe, merci bien. Présentation. I may now ask our second speaker, Jim Turk. This is one of the occasions where even a long bio wouldn't do justice. Jim is, of course, the distinguished visiting scholar at the Faculty of Communication and Design and director of the Center for Free Expression at Ryerson University. Many of you know him for the 16 years that he spent as executive director of the Canadian Association of University Teachers, and will know him in particular for the book that he was involved in, Academic Freedom and Conflict, the Struggle Over Free Speech Rights in the University, which was published in 2014. Jim, take it away.
Thank you so much, Michael. And I want to thank the Harry Crowe Foundation for the invitation to be with you today. The panel is being asked a key question. Is there a need to strengthen the legal and constitutional foundation of academic freedom? While the legal context in which academic freedom exists in any country is very important, it is misleading to understand the law as the foundation of academic freedom, at least in North America. To have a useful discussion of the law with regard to academic freedom, I think it's essential to consider several things: the unique nature of this freedom, the context in which it has arisen, and the societal function it serves. Then and only then can we address the question of whether changes in law are desirable or necessary to protect academic freedom. Let's begin with the basics. Academic freedom is a right that has arisen in relation to a particular institution with a particular mission, the university, a right that makes it possible for the university to fulfill its societal function of advancing knowledge and educating students to be knowledgeable, critical, and creative. The rationale for academic freedom derives from this mission and is lost if the mission of the university simply becomes the static reproduction of knowledge, as it was in many pre-modern European universities, in early American colonial colleges, and in some of the earlier Canadian higher educational institutions. And is a real danger of becoming, for all but the elite universities in Canada and the United States, because of what former Harvard University President Derek Bach termed the marketization of the university, and many others have described as commercialization. I'm going to come back to this at the end of my talk. I would like to suggest 8 key messages for you. The first is that the special right we call academic freedom is an institutional right, a workplace right. In short, without academic freedom for its academic staff, universities cannot succeed in their proper mission. Second message, just as we must be clear what academic freedom is, we equally must be clear about what it is not. Too often it is wrongly understood as simply freedom of expression for university professors, or used misleadingly to describe the necessary expressive freedom rights of students as student academic freedom, or mistakenly equated with institutional autonomy, or treated as a right of the university, the so-called institutional academic freedom, or to claim that individual faculty have full autonomy in relation to their teaching and research. It is none of these things. William Van Alstyne's description of academic freedom captures the key aspect, namely that it is a right of individual academic staff to be able to fulfill their roles as teachers and scholars. Marcel, could you put up the one slide, because I want to read his description. Is that possible? Academic freedom, Van Alstyne writes, is the personal liberty to pursue investigation, research, teaching, and publication of any subject as a matter of professional interest without vocational jeopardy or threat of other sanction, save only upon adequate demonstration of an inexcusable breach of professional ethics. In the exercise of that freedom, specifically, that which sets academic freedom apart as a distinct freedom is its vocational claim of special and limited accountability in respect to all academically related pursuits of the teacher-scholar, and accountability not to any institution or societal standard of economic benefit, acceptable interest, right thinking, or socially constructive theory, but solely to a fiduciary standard of professional integrity. Third message, it is a right that is recognized, defined, and demanded by those working within the institutional context in which it is required for them to do their work. Its effectiveness is dependent on the academic staff. You can take down the quote if you would, Marcel. Its effectiveness is dependent on the academic staff to which it applies, collectively being the ones that identify and formulate the necessary components of that right, adjudicate its academic boundaries, and lead the drive to have that right recognized, protected, and promoted. To the extent that the definition, implementation, and setting of its academic boundaries are given to or taken away by administrations and boards of governors, governments, or the courts, academic freedom is put into peril. In other words, all aspects of academic freedom are properly the jurisdiction of the academic staff. The more expansive the academic staff's role in all these aspects, the better it will be for the academic integrity of the university and the realization of the institution's mission in society. Fourth point, if we look back to the origin of academic freedom in Canada and the United States, we see that it emerged from the response of faculty to an irregular but persistent tension between governance by lay boards of governors and professors' notions of academic autonomy and the right to be guided by their professional judgment. In the United States, the arbitrary firing of faculty led John Dewey and other leading American academics to form the American Association of University Professors in 1915 and draft the first and arguably the foundational articulation of academic freedom in North America, the AAUP's 1915 Declaration. In Canada, the Canadian Association of University Teachers was founded, I think it was 36 years later, in 1951, as a result of faculty members' concerns about inadequate compensation and benefits. But the organization only became a meaningful entity in 1958, following the firing of Harry Crowe. The Crowe case made academic freedom a public issue in Canada and inspired CAUT to emulate the AAUP by appointing its first investigatory committee. The Folk-Alaskan report articulated both the professional nature and key elements of academic freedom that would come to shape CAT policy on academic freedom, and the eventual translation of that policy into collective agreement language that today covers almost all academic staff in Canada. The Folk-Alaskan report from this first commission of CAUTs included an appendix with the current AAUP policy and reflected a similar view that had been taken and developed by the AAUP. Fifth point, distinctively North American was the breadth of the conception of academic freedom, as we've heard earlier in this conference, recognizing four components: teaching, research and scholarship, intramural speech, and extramural speech. A conception which a Canadian, my predecessor as executive director of CAUT, Donald Savage, was largely responsible for getting the General Conference of UNESCO to adopt in 1997, and now constitutes the principal international statement on academic freedom. Not many people know of Don's role in that. 6, there are 4 not necessarily mutually exclusive options for making this broad workplace right a reality: normative, statutory, constitutional, and contractual. While specific constitutional and statutory protections for academic freedom are common in many parts of the world other than Canada and the United States, there is no consistent conception of academic freedom, nor common specification of it in those legal instruments. Nor has there been any careful assessment of what protection these legal and constitutional instruments provide in practice, as opposed to on paper. 7th, as we consider legal options, it's instructive to give close attention to the United States, where there has been a serious effort to give greater weight to the professional definition of academic freedom, as the AUP and CUT have, by linking it to the robust First Amendment protection for freedom of expression. Remembering that Canada's charter, like the Constitution of the United States and the First Amendment, has no reference to academic freedom. Please bear with me as I take you through a quick overview of the American experience to see what lessons it has for us. From its initial articulation of academic freedom more than 100 years ago, the AAUP sought to enforce academic freedom rights through normative means. The AAUP's principal tool was to launch investigations of alleged violations of academic freedom, to enter in discussions with university administrations for resolution where the investigatory committee found that there had been violations. And if there is no satisfactory resolution, to impose censure on the institution and to widely publicize the list of censored institutions. In addition, it sought to advance its conception of academic freedom as a norm in the American academy by engaging its employer equivalent in ongoing discussions about academic freedom policy. As a result, the American Association of Colleges, now the American Associations of Colleges and Universities, endorsed the AAUP's updated 1940 statement of academic freedom principles, and subsequently AAUP obtained further endorsement by more than 250 of the leading American scholarly and educational organizations. The prospect of linking academic freedom to the First Amendment came quite unexpectedly during the McCarthy years, when in the Supreme Court upholding a state law that allowed the firing of members of organizations, firing by universities and colleges and other educational institutions, of members of organizations deemed by the Board of Governors to be advocating the overthrow of the government by illegal means, Justice William Douglas, in his dissent, introduced the term academic freedom for the first time in a U.S. Supreme Court decision. He wrote that the disputed law's system of spying and surveillance cannot go hand in hand with academic freedom. The effort to constitutionalize academic freedom in the United States reached a high point 15 years later in 1967 in the Supreme Court's decision in Kishin, where Justice William Brennan, writing for the majority, observed that the United States, and I quote, is deeply committed to safeguarding academic freedom, which he termed, quote, a transcendent value to all of us and not merely to the teachers concerned, adding that academic freedom is, quote, therefore a special concern of the First Amendment, which does not tolerate laws that cast the pall of orthodoxy over the classroom. Auspicious as this may have seemed, over the past 5.5 decades, American courts have effectively created a quite different understanding of academic freedom that undermines the conception of academic freedom as a professional right of academic staff necessary for them to fulfill their duties. Instead, American courts have defined academic freedom in institutional terms as a right of the institution, not of the individual. Rarely, for example, when American courts have invalidated termination or other discipline due to utterances critical of administrations, have they mentioned academic freedom. Justice Thurgood Marshall, in writing for the majority in Pickering, explained, and he said, the state has interests as an employer in regulating the speech of its employees, which parenthetically I should note includes academics in public universities. And Marshall continues, I should note that the U.S., he added that this differs significantly, its interest in in public employees, its interest in regulating their speech differs significantly from its interest in protecting the regulation of speech of the citizenry in general. Subsequently, in a case known as Urofsky, the Fourth Circuit rejected the first academic protection for faculty members, stating, quote, our review of the law leads us to conclude that to the extent the Constitution recognizes any right of academic freedom above and beyond the First Amendment rights to which every citizen is entitled, the right inheres in the university, not in the individual professors. 6 years later in Garcetti, the leading case in speech rights for public employees, the Supreme Court ruled that First Amendment protections do not apply when individuals are speaking as employees pursuant to their official duties rather than as citizens, adding both that there may be reasons why this does not apply in relation to, quote, academic scholarship and classroom instruction, but they didn't need to deal with that, they said, and so they didn't. Since then, the circuit courts across the United States have adopted what one commentator has described as a dizzying set of rules as to when First Amendment protections apply in the academic sector. What that has meant is that a faculty member punished for her speech may receive First Amendment protection in one circuit, court's jurisdiction, but not in another. Of course, no one teaching in any of the United States private universities, from Harvard and Stanford to Hiram College, has any First Amendment protection for their academic freedom rights. So my seventh point is that academic freedom in the United States, having been declared a special concern of the First Amendment almost 55 years ago, is worse for the judicial embrace. The eighth point, this is an important object lesson for Canada. It should make anyone rethink the suggestions that we should seek to enhance protection for academic freedom through linking it to Section 2B of our charter. Putting aside now for this question of whether universities could ever fall under the charter in relation to teaching and research, and putting aside that the charter provides much less protection for expressive freedom in general than does the US First Amendment. Far from helpful, success in linking academic freedom to the charter would, I suggest, pose a needless danger to the exceptional protection for academic freedom that Canadian academics enjoy, quite possibly the strongest in the world, that has been achieved through a combination of normative and contractual means. There is much more to be done, especially in making that protection stronger for contract academic staff, but there is a danger in trying to do that through constitutional or statutory means. I'd like to conclude. Academic freedom has been and continues to be at risk. Like all freedoms, academic freedom is never secure, but must always be in the process of being secured. Nothing has provided more real and effective protection for academic freedom than the combination of normative and contractual approaches taken in Canada. First, CUT and academic staff associations across Canada have followed the example of the AUP in defining academic freedom as a professional right. They have worked to embed it as a central norm in the Canadian Academy through public advocacy, collaboration with university administrations that shared CAT's perspective, actively challenging those that did not, undertaking formal investigations of apparent violations, raising the prospect of censure when the violation could not be otherwise remedied, and imposing censure as a last resort. Secondly, following the initiatives of several faculty associations starting in the 1960s to unionize, CAUT came to promote unionization, the remarkable success of which has meant that the professional definition of academic freedom has been written into collective agreements of almost all academics in Canada, providing the optimal legal basis for protecting academic freedom. I say optimal because the definition and scope of academic freedom is developed by the academic staff, embedded through negotiations and collective agreements. And so when disputes have to be adjudicated, it is by arbitrators, as Michael Link was talking yesterday, typically more knowledgeable about the academic context than judges, and whose decisions are based on the language of the collective agreement, largely shaped by the academic staff, rather than what was written by governments in statutes or constitutions. There remains limits to academic freedom as have been addressed in this conference earlier. The principal ones are collegially determined professional boundaries that define and prescribe research misconduct, plagiarism, unethical treatment of students, incompetence, lack of productivity, or neglect of assigned duties. There are, in addition, statutory limitations, as Peter Jacobson was discussing, that apply to all in a society, such as prohibitions on libel, slander, discrimination, harassment, violence, or threats of violence. While many challenges remain for effectively protecting academic freedom in Canada, those challenges can most productively be addressed by strengthening our normative contractual approach to academic freedom, not seeking constitutional or statutory protections. But all of that becomes moot if we ignore the principal threat to academic freedom, it becoming irrelevant in the context of the marketized university. Thank you very much.
Thank you very much for that, Jim. That was a wonderful and systematic overview on academic freedom. I was taking notes the entire time. If I can turn now to our third speaker, Linda May McKay-Panos. Linda is the Executive Director of the Alberta Civil Liberties Research Centre, which is affiliated with the Faculty of Law at the University of Calgary. She holds a BEd, a LLM, and a master's degree. And she's the author of several publications dealing with civil liberties, access to information, human rights, discrimination, equality, and related topics. Linda, may I turn it over to you?
Thank you, Michael. Is my volume good?
Yeah, your volume is fine.
Okay, great. First of all, I think I need to say I'm not speaking on behalf of the University of Calgary, just to be clear. I'm speaking on behalf of the Research Center. It's very difficult to follow Professor Turk because, of course, I have an opposing opinion. So if we can, by opposing, I mean there is some value into looking at the charter, at least charter values in the context of academic freedom. Could you turn to the next slide, please? Next one. So while I was doing my research for this presentation, I came across this in a news report, and I thought it was so good about pointing out some of the current tensions that many of the speakers have mentioned. And it's about a professor from our Mount Royal University in Calgary who was fired for certain things she said after there were some petitions and other activities. Now, some of the concerns were to do with her viewpoints on Indigenous issues. Next one. So in firing her, the statement made by the university was Mount Royal employees have the right to work in a respectful and free environment from harassment. And I think a couple of the speakers mentioned that earlier. And so what you have is they're saying that she has created, her speech, by the way, was both intramural and extramural. And so this just shows you that they've used creating poisoned learning environment as justification for firing her. Next, please. And she talks about the woke culture. And I must confess, I had to look that up because I hadn't heard that term before. But I noticed a couple other speakers using it. So it's my lack of knowledge that is at issue here. But the idea that people feel that they've awakened to their new rights and the terrible identity issues that they've experienced over the years, and that trumps any kind of academic freedom or freedom of expression. And what's interesting too is, now this is from the Professor Widowson's perspective, of course, is that she said she was hired specifically to be a critic of Indigenous policy. And she received her PhD from York University. Next, please. So it just causes you to think a little bit about, first of all, how was the university, if it's true what she says about why she was fired, how can the university then justify firing her for doing what she perceived was her job? And it'll be interesting to see what comes of this. So as Professor Link talked about earlier yesterday, most of the statements about academic freedom are in the context of other kinds of disputes and are, for the most part, obiter. And many of the court decisions, for example, the McKinney case, interestingly, is what they call an internal matter. So it was somebody who was asked to leave because of, alleged age discrimination, and actually the human rights law at that time limited age to 65, and she was over 65. So she had to try to use the charter to make her argument. And so comment like Justice Laforet in McKinney includes academic freedom and excellence is essential to our continuance as a lively democracy, and they are talking about the university's objective for having rules on this particular topic. Next. Thank you. He goes on to say, tenure provides academic freedom, and it allows and this is his definition, the free and fearless search for knowledge and the propagation of ideas. Now, Justice Wilson had a very strong dissent in this and many other cases. And she, one part of her discussion was about academic freedom. And again, it's just a generic statement that academic freedom serves the protection and encouragement of the free flow of ideas. Next. So on to what has stirred up a whole lot of things in Alberta is a line of cases in Alberta and Saskatchewan, and I'm from Saskatchewan, by the way, just by way of disclosure. The Pridgeon case is so interesting because it was decided, two students wrote some offensive or allegedly offensive comments about a professor, sessional instructor. And at the Court of Queen's bench, they were actually allowed to argue that freedom of expression would protect that speech. But the matter was appealed to the U of C. The U of C appealed the matter, and the argument about the application of the charter and everything was really not dealt with on appeal, except for by Justice Paperny, because the other two decided the matter on on administrative issues. And so for that reason, this is all obiter, but it's so interesting because she took quite a bit of time to talk about the relationship between freedom of expression and academic freedom, and said that it does not trump freedom of expression. That's first thing she says. Next. And so she rejected, by the way, you notice that several interveners, including probably CAUT, supported the university in the idea that the charter would not apply. Sorry, did I say something bad? Yes, thank you. So the application of the charter was undermined the university academic freedom, and she rejected that argument. Next, please. And so the Supreme Court, she goes on then to explain what freedom of expression has meant. And I have to tell you, one of the reasons why I'm really thinking about what role the charter could have in all of this is because of the extensive jurisprudence on freedom of expression and the care that the court has gone to in recognizing that freedom of expression is a very important right, and that should only be limited in very specific and careful circumstances. Next. Thank you. Academic freedom and freedom of expression, in her opinion, are not competing values. While freedom of expression is guaranteed to everybody, academic freedom is usually confined to the professional freedom of the individual academic in universities and so on. New ideas and unpopular opinions without being in jeopardy within the institution. Next, please. And of course, there is an aspect of academic self-rule to academic freedom, the idea that they have an aspect of decision-making and also institutional autonomy. So this entire section talks about the relationship between academic freedom, freedom of expression, and institutional autonomy, because the argument is most of the cases do not differentiate properly between those three principles. Next, please. She talks about the fact that they can not be unlinked. They're inextricably linked, those two. She also says, for example, the protection of free speech does not necessarily threaten academic freedom. Next. Could I have the next one? Thank you. She goes on to talk about the conflict between academic freedom and freedom of expression. She says they're handmaidens to the same goals: meaningful exchange of ideas, promotion of learning, pursuit of knowledge. And she believes that they can coexist. And that if there's any situation where those are not the values that have come up, we have section 1, and I'm just going to address that briefly in a moment, to help us balance everything. Next, please. I have to tell you, though, there's a big deal of confusion about whether or not the charter applies to universities at all. We have BC and Ontario cases that basically say no, it doesn't apply, at least in the context of student groups and certain protests and things that are going on at the university. And then the other line is the Alberta-Saskatchewan line that has found many contexts where the charter actually applies, including a person charged with trespassing for putting literature on the windshields of cars. He's famous. He puts literature everywhere in Alberta and Saskatchewan, and his name is Watcott. Hopefully he won't sue me for defamation. Next, please. So I've talked about that. Next one. One thing that I didn't include in my presentation that I use in my classes, I teach constitutional law, is that what's so useful about Justice Paperny's judgment is that she goes through the entire academic discussions, court cases, and divides the situations where the charter might apply to 5 circumstances. And again, there's a disagreement between BC and Ontario and Alberta and Saskatchewan on this. So for example, she would argue that a case called Eldridge tells us where a private institution, including a university, for example, is implementing a public statutory authority or applying something, that would be enough to bring the charter into apply. So it's very interesting, 5 analysis of 5, and it's been followed in many cases, particularly most recently by the Court of Appeal of Alberta in a case involving pro-life demonstrators having to pay a huge deposit. Next. So the Chambers judge, of course, went through the entire, the Chambers is the Court of Queen's Bench, the lower judge said it's not unqualified. The university has to be able to place reasonable limits on speech. And I know that that's a phrase or a word that people don't like, but I'm going to go on to explain to you why the court is such a handy tool, because they've spent a whole lot of time talking about what a reasonable limit is. Next, please. So I love to draw pictures. And this is a diagram that I use in my classes to talk about the role of the court. Oh, can you go back one? The role of the court in, thank you, in assessing speech. First of all, on the right-hand side of the line, threats and threats of violence are not protected at all by freedom of expression. That's clear from the case law. So that's out of the formula. But there's 2 different kinds of or categories of speech that's recognized by the court, Supreme Court. One is high value or core speech. So you have, which I think much of academic kind of speech fits into, pursuit of truth, political speech, and the pursuit of self-fulfillment. And why it's called core speech is that if the government seeks to limit that, then you have the government has a very high onus to prove that their limit is justified. So in other words, they're put to the test, and there's a whole lot of factors applied by the courts to decide whether or not the limit could be justified. Then you have on the other side of the formula, the low value speech, and that is hate speech, even commercial speech, which is interesting in view of some of the conversations we've had about the marketization of universities. I don't think that's the way it's meant, but maybe we could make an argument. And then obscenity. So that means the courts are going to defer more to the kinds of limits that there are on that type of speech. And I think they're quite consistent in what they've done. There have been a few cases where I might have disagreed, but I often disagree with the courts, and they don't really mind because they don't care what I think. But in any event, these are the reasons why I think at the very least, charter values should be in the formula when we're dealing with academic freedom. And then I include a silly cartoon at the end. I don't even know if it's true, but if you could move one forward, please. So I'm anxious to hear questions, and I'm finished. And I hope I didn't go over my time too much. I was watching my clock like a hawk.
Thank you very much, Linda, for that. That was a great overview with respect to the charter and the interplay between academic freedom and freedom of expression. Our fourth and final speaker on the panel and our last speaker of this conference is Craig Davis. Craig is a partner at the Vancouver labor law firm of Victory Square Law Office. He has his degrees from the University of British Columbia, and I'm proud to say he was a student of mine when he studied for a master's degree at the Osgoode Professional Development Program. He represents, among other clients, academic faculty unions, and perhaps one of the many noteworthy accomplishments he's had in his career is that he successfully argued the Saskatchewan Federation of Labour case at the Supreme Court of Canada, which resulted in a major victory for labour unions on the right to strike issued by the Supreme Court 7 years ago in 2015. Craig, may I turn it over to you?
Thank you, Michael. And I should just note, I'm speaking to you from the unceded territories of the Coast Salish people on the west coast of Canada, where it's just afternoon. And that's a tough act to follow, going last on the last panel, trying to, there's some very significant presentations to try to catch up with and meet. The topic of this panel is looking to the future. What is the future of academic freedom? I'm going to give you my perspective as a labor lawyer practitioner. If we could have the next slide. In short, academic unions, I think I would have to echo the comments of a number of the panelists that academic unions best can protect academic freedom by inclusion in collective agreements and staying in arbitration. More increasingly, we're seeing the post-secondary institutes are trying to exert more control over courses and teaching assignments, which threaten academic freedom. Justifications have ranged from COVID-19, elimination of mandatory retirement, distributed learning modes, and competitiveness with other post-secondary institutions. Unions face views that academic freedoms are earned through trade-offs and collective bargaining, notwithstanding the strong traditions of academic freedom, which predate unionization. This is the reality in which unions are having to fight for these rights. And I want to just finally comment on what I see as a new area in which more litigation will probably fall, in which there may be some scope for unions and instructors to gain some more control, and that's looking over the teaching conditions and course organizations as aspect of academic freedom, which is different from the traditional freedom of inquiry, freedom of expression that academic freedom typically focuses on. Next slide. Okay, next slide. I just want to briefly comment. I'm not going to spend a lot of time on this, but as we've heard many times, the Supreme Court of Canada has recognized that universities, although not colleges, are autonomous institutions to which the Charter applies. There is an understanding that deference is needed to these institutions in order to allow them to maintain their academic freedom, such that universities are not governed actors. Yet colleges, because they are seen to have a greater degree of control through their financing and appointment of governors by government to be subject to the Charter, so policies and their actions can be considered law, which is why mandatory retirement is struck down by the Supreme Court of Canada in colleges, while universities not so, and they're allowed more to exercise their own discretion over their own policies. It's interesting when you read cases like McKinney, you'll see that the court really understands academic freedom and the balances within an institution as products of collective bargaining, to which they're going to be given deference. And I'll come back to why that may be a problem. But ultimately, the court does recognize, particularly in Douglas College, 1992, that even though a arbitration board is not a court of competent jurisdiction in the sense that they're a superior court, they do have sufficient power and expertise to be able to hold that discriminatory policies or things that violate the Charter are not going to be, they've got the ability to make that ruling. Even though they're not courts. So by and large, I mean, the courts have found that they're going to defer to the universities, and typically, for the last 30 years after McKinney cases, the courts have, largely been avoiding wandering into Charter territory, leaving that primarily for the collective bargaining relationships and labor arbitration. I'm going to get the next slide. The foundations of this are probably set out best in the University of Regina case, and this is the seminal Supreme Court of Canada case, which really recognizes why, ultimately, there has to be some autonomy here, because they describe the governing bodies as tribunals, and there's a sense really that the internal governance of universities is appropriate, needs to be respected and left alone. We see that, through these various statutory grants of power that courts give, that legislatures have recognized for academic post-secondary institutions, such that there's an understanding usually that, the internal processes of a university will typically provide sufficient due process and natural justice when it comes to protection of important interests, such that the courts only rarely intervene on judicial review, not on the merits, but when there's been a violation of those fundamental tenets such as natural justice. Next slide. One of the things that, we find, though, in labor arbitration is quite a struggle to find sources of authority to define academic freedoms. And I can tell you, academic freedoms are one of those concepts that are self-evident, I think, to academics and those that teach and participate in the university communities, not quite so for lawyers and arbitrators. This is why I think there's a huge value in having ultimately collective agreement to find definitions of academic freedom over statutory definitions or protections, simply because it's difficult to try to adjudicate statutory definitions. One of the longest cases I ever dealt with was a 55-day hearing in which the School Act contained a definition for the organization of classes on the grounds of appropriate for student learning. And I'm sure the educators that agreed to that language or proposed that for the statute had a great understanding of what it meant. But if you give lawyers the term appropriate for student learning, litigation. Same thing with academic freedom. It might, the academics might know what it means, but ultimately, when you throw lawyers at it, it can mean a lot. One of the things, though, I do notice that there's other sources that arbitrators are happy to go to: government policy documents, which talk about reasons for organization of funding and internal processes, judicial decisions, of course, arbitral decisions, but also academic journals can be a really good source, particularly in enlightening arbitrators who may not understand academic freedom and collegial governance, which are really foreign concepts. One of the other areas in which I find is particularly useful is to look at international law, particularly the ILO recommendations concerning the status of teachers from 1966, and the UNESCO recommendations concerning the status of higher education teaching personnel from 1997. Next slide. Next slide. So it's interesting that almost, over 30 years after McKinney and the University of Guelph, a number of the panelists have quoted it. And one of the challenges of it poses one of the difficulties with litigating in the courts, and that's getting past what the Supreme Court of Canada says. I think when I read McKinney that the court doesn't understand academic freedom. On the one hand, the court says, look, we're not going to intervene in the mandatory retirement policies of the University of Guelph. These are collectively bargained. We think the universities should maintain them, and we're going to step back. And they really put a lot of emphasis on the fact that these are, bargained by positions of academics and the institution who are relatively equal in power. But if you read McKinney, after they say we're not going to go into, we don't need to decide whether or not this is justified, they then go to articulate what they understand as academic freedom, which I find, based on all the academics I've spoken to in the last 2 or 3 years, to find completely at odds. There's a fundamental linking, the court says, between academic freedom as a trade-off for mandatory retirement. Next slide. The justification for not interfering is because they assume that there was a trade-off between mandatory retirement and the tenure system and academic freedom. The sense is that academics have a shelf life, and that once they hit 65, you need to rotate them like you would produce at a grocery store. The whole idea that faculty renewal is a necessary product to enable universities to be centers of excellence. They need to be on the cutting edge of new discoveries and ideas, and this requires a continuing infusion of new people. In a closed system with limited resources, this can only be achieved by departures of other people. I think maybe this was an element of, 30 years ago, but I think most academics, at least those I've spoken to, don't think that academics, suddenly become stale at 65, and the only way an institution can survive is by mandatorily retiring them. Next slide. Could we get the next slide? Okay. Oh, sorry, back one. So yes, excellence in our institution is important, vital to society. Mandatory retirement significantly considers to an enriched working life for its members, ensures faculty have a large measure of academic freedom and minimum supervision performance review throughout their period at the university. So that's, what the Supreme Court of Canada says, and I appreciate, as some have commented, that this is obiter, but we see it now increasingly working its way into justifications for administration trying to assert more control over academics. And if you haven't encountered this in bargaining, stay tuned. It may be coming to an institution near you. Next slide. I think there has to be a very, concerted effort on the part of academic unions to ensure that the idea that academic freedom is there solely because it's a product of bargaining trade-offs does not become the framework through which these are described. The labor arbitration system often assumes that those rights that are held by management are intrinsically management's, and the union achieves freedoms and rights in the workplace by negotiating them away from management. So decisions about who and how to control the workforce, who gets to apply for what position, the basis of recognition of seniority, all have to be negotiated away. The more we, though, see, and this is why mandatory retirement is so troubling, because of this conception that there was a trade-off somehow, and that the faculty of universities traded off mandatory retirement for academic freedoms. There needs to be a lot more attention paid to the fact that academic freedom long predated the unionization of university campuses, and when collective agreements came into play, it was meant to recognize those existing rights and codify them, to protect them, not to create new rights. With the end of mandatory retirement, some of the cases we are seeing are justification for greater scrutiny of tenured academics, increasing use of non-tenured instructor, and exerting greater control over course offerings, over the idea that there needs to be new infusion of ideas, and we have to keep the courses and offerings fresh. And we can't do that if academics continue to stick around. Of course, that's ignoring the entire dignity issues that occur when you discriminate against people based on age. But this is a worrying trend, and this is what I think is going to be one of the trends that you will see increasingly in the next 5 years in bargaining, these attempts to try to use this justification to achieve greater control over hiring and course assignment. Next slide. One of the things I'd like to talk about is, some of the new challenges that we are seeing, at least from a practitioner's perspective in British Columbia, particularly, certainly other places. We have seen COVID-19 and the requirements to have public health responses to that pandemic be used to justify distributed learning and assignment of courses. Previously, in a collegial governance model, we had a scenario where instructors would often plan what courses were offered, who would teach them. And there are a number of cases in British Columbia where, under the guise of COVID, those rights were effectively nullified under the guise of expedience. We see cases now where instructors are required to teach from home, told they must stay on campus, told they are not coming off campus. I think this is really going to be the next wave of grievances and litigation. One of the ones that's quite helpful in discussion of this is Dalhousie Faculty Association. In this case, the grievance ultimately against the changes imposed by the faculty, by the university on the faculty during the COVID-19 pandemic are dismissed because the association was cooperative and negotiated the language of understanding with the university. However, the arbitrator does note that had those not been negotiated, some of the changes that were imposed under COVID probably would not be justified. If we get the next slide. One of the cases that I think is really interesting, and I can just talk about as I had some experience with this, is dealing with the equivalent of academic freedom in post-secondary, which is professional autonomy in the K-12 sector. And it's one of the very few cases out there on autonomy rights and distributed learning. For those of you that don't know, in British Columbia, there are a number of districts, including Kamloops, where this is from, in which districts can make another $5 million a year through distributed learning courses. If you've got a mill set up, you can have a couple thousand students taking online courses. Here was a case where a teacher taught distributed learning. She had concerns because the administrator transferred students out of her classes, assigned final grades to her students, and allowed her to write examinations at the administrator's discretion, not the teacher's. The administrator directed the teacher to allow students to write online exams at private tutoring centers against her views. So this was a question of whether or not these were professional autonomy. Not the typical professional autonomy or academic freedom cases you hear about, which look at criticism intramurally and extramurally, or the choice of content of on how to deliver courses. But these are what I call the organizational aspects of courses. Next slide. So briefly, there were a number of questions the arbitrator looked at. First of all, if the administrator gives a student passwords so they can write an online exam without the consent of the teacher, is that an infringement of professional autonomy? Next slide. The arbitrator found that it was, and professional autonomy not only protects the ability to teach a lesson or a class in the manner that the teacher sees appropriate, but also to determine when students should be assessed for learning. And this is, critical because, as you may imagine, instructors get a lot of pressure from students to be able to write exams to move through their courses quickly. When the teacher said, no, you need to redo an assignment, they would go to the administrator who would override the teacher. So the ability to control when a student writes an examination and proceeds through a class is based on a teacher's judgment, even though that may not be typically thought of as being professional autonomy, as the exam was still the teacher's and the content was still the teacher's. Ultimately, determining when the student should proceed through that was protected by professional autonomy. Next slide. Next question. This was a really interesting issue because a number of students were only in the Grievers English 12 class because they had enrolled in the English 12 class through a private tutoring center. In order to get into university, you need a high mark in English 12. So a number of students, international students in particular, would register with a private tutoring agency in Vancouver and then take this online course in Kamloops. The reason why, because the Kamloops School Board would pay the tutoring centers an exam writing fee of $50. Every time they wrote the exam. The griever thought this was a conflict of interest. If you're a private tutoring company and have a financial interest in the students' doing, you shouldn't be invigilating the exam. So she refused to allow the students to write there. Management directed, saying this is no infringement of your autonomy. This is simply a case of where the tests are taken. Next slide. The arbitrator did find that was protected by professional autonomy, though. She was fully entitled to raise perceived concerns. Yes, I just see Michael's giving me 2 minutes. So we're properly administered and vigilated by testing centers. The griever had the right to insist on independent vigilators to properly assess. Next question, slide. You might find this interesting, or maybe not. I mean, it's the principal was not allowed to change the grades. Next slide. Of the students in the class without consulting her. What ultimately the arbitrator said was, if you have a concern with the grade that the teacher is assigned, you can't, as an administrator, impose a grade on that student in that class. Rather, you have to transfer that student into another section and put the name under another teacher. In other words, the grade attached to a transcript under a teacher's name for a course was seen to be a stamp of carry the weight of the professionalism of that teacher. And finally, the last slide. Did it infringe the professional autonomy when the principal reassigned students about the griever's class into other classes without consulting her? Next slide. Yes, that was found to infringe autonomy. So even the idea of moving students out of a instructor's class into another when they've got concerns was found to engage the professional autonomy. Importantly, because the reputation of a teacher depends upon their standing with their students. And if the thought is that, if you've got a complaint about the teacher, that it can be easily addressed by moving the student without giving the teacher a chance to reply, that is going to breach autonomy. So I'll just finally wrap up and just summarize what I see as the trends that we're going to see in the next couple of years. From my perspective, we are going to see in future trends that labor arbitration continues to be the principal forum for adjudicating academic freedom issues. We'll see more reliance on new sources of academic freedom to describe those rights, particularly international law, as we struggle to understand and get arbitrators to understand it. I think post-secondary institutes are going to continue to seek more control and constrain academic freedom, trying to minimize it as a bargained right, not an intrinsic right that doesn't have, that it's not created through negotiation. I think you're going to see the focus on the teaching conditions and assignment of classes as being more prevalent disputes. And ultimately, as if we as lawyers do our jobs and properly educate arbitrators, I think you're going to see a more robust understanding of academic freedom, although it may have a more technical side, and we may get more into the importance of teaching conditions, how and when a teacher's instructor teaches, particularly whether the issues of surrounding teaching from home. And just one final point. Next slide. I think that's it. I would just want to caution, I wanted to go into a bit more about this, but one of the advantages, of course, to keeping adjudication of charter issues and academic freedoms within the labor arbitration forum is you're less likely to have to deal with competing rights. The U.S. right now, the most interesting areas of academic freedom deal with the collision of the Second and the First Amendment, in which teachers are challenging campus carry laws the legislatures have passed in the U.S., which allow students to bring concealed weapons into classrooms. And the claim that infringes upon academic freedom because teachers don't like instructing when students have firearms that are concealed in the classroom. Interesting conflict of constitutional values that occurs there that we may be able to avoid if we're in a labor arbitration forum. And I think I'm past my time, so thank you.